I think we can already start. Again, thank you very much for joining us in our book launch. It is one of IPRI's crucial, important publication. It aims to provide a comprehensive view of the criminalization of Adivasis, and it traces its links to colonialism and the continuing discrimination against their identity and way of life. Again, for those who just came in, kindly introduce yourself in the chat box, write your name and your organization. The chat box function will put off after the welcome remarks, just to help us focus better in the discussion. Now, if you need to raise your questions and comments, please use the Q&A function. You can find that below the window of your Zoom. You may wish to specify the speaker you wish to respond to your question or comments, and the panelists have the option to respond to them directly through the Q&A function. They can write them. Otherwise, we'll go through them at the very end of the presentation of all the speakers. Now, as not to let everyone waiting, I'd like to ask IPRI's Executive Director, Ms. John Carling, to kindly formally open our event for today. John, please, the floor is yours.
Yes, thanks, Joyce, and good morning, good evening, good afternoon, and good day to all of you in this important session, and would like to warmly welcome all the participants, including our esteemed speakers, for this important launching of the report on examining the Indian legal system and criminalization of Adivasis. The Indigenous Peoples' Rights International has commissioned this groundbreaking report to contribute in raising awareness and understanding on the legal status of Indigenous peoples in India, and in relation to the challenge of criminalization of Indigenous peoples in India. We know that India is so-called the largest democracy in the world, but how is it treating the Indigenous peoples in India, which is also one of the largest population of Indigenous peoples in the world? So the report examines this situation, and I will not, of course, go into that because some of our speakers will cover that issue. The other dimension of why the Indigenous Peoples' Rights International, IPRI, has commissioned this study is because it is one of the main issues that IPRI is working on, the issue of criminalization. And the reason why IPRI was established was because of the findings of the report of the former Special Rapporteur, Ms. Victoria Tauli Corpus, who is also the co-founder of IPRI, in relation to the huge gaps and challenges faced by Indigenous peoples in relation to the issue of criminalization, violence, and human rights violations with impunity. So IPRI was then established to look into these issues at the global level and contribute in the prevention and also reduction of these problems. So while it has a global focus, it also focus, in a number of countries where these issues are very, very blatant. And India is one of the countries that we have identified to work on this issue. We have also the Philippines, of course, where I come from. Then we also have the Democratic Republic of Congo and Africa. And in Latin America, we have Mexico, Brazil, and Colombia. So we also did similar studies on the dimensions of criminalization in these countries. And the first one that we have issued is in Brazil. The report was launched last year on the different dimension of the phases of criminalization in Brazil. And we now have India, and by July, we will launch our report on Colombia during the expert mechanism on the rights of Indigenous peoples. So this is just to say that this issue really needs global attention, but also national focus, because it's national laws that are criminalizing indigenous peoples and are not providing access to justice. And these are the issues that has to be addressed immediately with sense of urgency. So we are very honored and privileged to have collaborated with experts, with legal experts who are the authors of this report. And we do recognize the commitment, the sacrifice, and the dedication that they have put in putting this report. I mean, the report was being prepared in the midst of COVID, no? So the members of the team actually were undergoing personal losses and distress, but they persisted in preparing this very important report. So we really express our deep appreciation to the work of the team for coming out with this report. I personally would like to sincerely thank Shomona for taking the lead and really have done so much sacrifice to get this report done. And we are very much honored to have this kind of excellent and very scholarly report. We are also honored to have distinguished and respected legal experts in India to be with us in launching this report. And we anticipate to hear from you in your insights and reflections. And we believe that this will further enrich the report as we move forward in working together for the better recognition and protection of the rights of indigenous peoples in India. So again, welcome, and I look forward to hearing from our speakers. Thank you.
Thanks very much for that, John. So just to get things going, let's move to our first panelist, Professor Faisan Mustafa, who is the Vice Chancellor of National Academy of Legal Studies and Research, University of Law in Hyderabad. He's known for his institution building abilities and democratic leadership. He has taught in several reputed institutions in India and abroad. He has written 8 books and contributed to more than 250 articles, and is known to have been quoted by the Supreme Court of India on a number of occasions. He also regularly writes in newspapers and magazines on current legal issues. He's a pioneer in making legal education accessible. His YouTube channel, Legal Awareness web series, who I believe has more than 500,000 subscribers, is known for helping people understand complicated legal issues in simple language. Professor Mustafa, please, you have the floor.
Thank you very much, Joyce. First of all, let me apologize to all the Adivasis for the excesses and atrocities which we on our legal system has been committing on them. I must compliment Shamona, Astha, Pooja, and Khushbu for working very hard in coming up with this book, which has 11 chapters, and one can only cry reading the kind of treatment we are meting out to the indigenous people. We are also grateful to Indigenous Peoples Rights International for sponsoring this research, which is an eye-opener, and we should be really ashamed of our system, which is not treating them even as a human being. The dedication of this book to Adivasi prisoners and those who dare to work with her really brought tears to my eyes, because this number of people who are willing to stand by Adivasi prisoners is, with every passing day, dwindling and going down, and those who really dare to do it have huge consequences to face. I also feel that unlike scheduled caste, who have a huge political constituency and whose votes every political party would like to have, Adivasis and scheduled tribes, in spite of their number being 8.6% of our population, but since they are scattered, they do not make such a big political constituency. So when we got an atrocious judgment from the Supreme Court diluting the provisions of the SC/ST Atrocities Act and trying to protect the accused, you had a huge hue and cry, and within months, the parliament intervened to overturn the Supreme Court judgment. Of course, subsequently, another bench of the Supreme Court itself recalled its regressive judgment. But such incidents and such cases for scheduled tribe are very, very rare. I would also like to say that this whole business of criminalization is not peculiar to Adivasis. We as a nation presently feel that doing over criminalization will make us a better society. There has been a continuous departure from the classical principles of criminal justice system. We have been reversing the burden of proof. We have been enlarging the definitions of crimes. We have been going against the principles of sentences which are to be prescribed for various crimes. For the smallest of the crimes, when one adult marries another adult of different religion, we are prescribing major punishments running into 10 years of imprisonment to 14 years of imprisonment just for choosing a spouse of one's own choice. For eating beef, similarly, if you look at our cattle laws in the recent past, we have simply given a big go-by to the Indian Penal Code's scheme of punishment and prescribe punishments which are ideally there for homicide or other major crimes. Even the colonial masters, about which the book which is being released today and about which we are talking, has made a lot of hue and cry that the colonial masters were so unjust that they came up with the dangerous tribe law and declared hundreds of tribes as dangerous, about 150 Adivasi communities. But still that regressive, non-democratic regime in the criminal justice system had provided some provisions which were compatible with the rights of the accused and which showed some civility. Because ultimately the maturity of criminal justice system, in my opinion, shows where we are as a civilization. If you look at the primitive criminal law, we were punishing people just because someone did some act. So mens rea was not to be considered. Mere actus reus or doing of a prohibited act was enough. If I was the owner of an instrument which was used in the crime, my ownership was enough to punish me. Most of the convictions in the primitive criminal justice system were based on confessions. Now, if you look at the Indian Evidence Act, even our colonial masters said that confession made to a criminal, confession made to a police officer shall not be admissible. Now, through laws like POTA and TADA and UPA and several other security laws, we are making a huge departure from even the protection and rule of law provisions which the colonial masters provided. The presumption of innocence, as the book has discussed in detail, is being reversed. We are now presumed to be guilty. Our mere existence makes us criminal. I know a Supreme Court judge who was born before 1952 when this law was, repealed, that he was indeed declared as the dangerous, member of a dangerous tribe. And subsequently, he became a Supreme Court judge and then was also the chairman of our National Law Commission. We are reducing the discretion of judges in sentencing and coming up with mandatory minimum sentences. So I believe as such, from the
Yo
narrow
creo
definitions of the crime, we are
que usando esta definición que estamos usando, se puede definir estos delitos. Ahora hablaremos de la autoincriminación. Están usando distintas cosas como la biométrica.
For convicts as well as for other persons. So I personally believe that we are rewriting our criminal justice system. Of course, the government of India has also appointed a committee which is looking at our criminal justice system. But if ordinary citizens are treated like this under criminal justice system, one can make out what is the situation about Adivasis. The identity violence, as the book rightly states, that once a criminal, always a criminal. Just like the rigidity of caste, we have extended criminality also to the tribes. I believe mere existence of people, particularly Adivasis, makes them criminal. And these laws legitimize violence against them. What frustrates me that even the Supreme Court and some of the recent laws, rather than making a departure from such a regressive legal regime, are reinforcing it and bringing it in new forms. The kind of decisions which have been given by the Supreme Court about evictions are frustrating. The kind of cases which are filed against these tribals like sedition or waging war are frustrating. In the name of barrier to development process, we are making such grave charges against them. And just because somebody could not prove his claim to forest, we are just throwing them out. In fact, the treatment of modern judiciary, otherwise liberal judiciary which in past had stood for the rights of the people, the way they are now looking at the whole criminal justice system is not only mechanical, but deeply frustrating. I also liked in the report the portion where we are talking of accused and complainant. If somebody is an accused, how the law treats him. And when the same person goes as a complainant, there is no equality and the law does not treat him in the same way. Therefore, I am personally sad after reading this report, even though about some of the points like the conviction rate of 28%, I have doubts about it, even though this is what the NCRB report says. But I don't think even 28% is the conviction rate. Some 10 states, which are Schedule 5 states, and they are the numbers about UPA and numbers about sedition charges pending in the court, about 95% is deeply frustrating.
Sorry, Professor.
Just I'm last
Yeah.
sentence.
All right, no worries.
And the way we are filing FIRs, if you take the example of Pathalgadi, on the basis of some Facebook post and some likes, I think we are making the mockery of our criminal justice system. The criminal justice system in good old days was tilted in favor of the accused because criminal justice system is an instrument of a state. The idea was that let the rights of accused be protected so that the state does not take undue advantage of its position, because parties in criminal justice system are uneven. On the one hand, you have the might of the state, and on the other hand, you have an ordinary individual, an Adivasi, pitted against the might of the state. We are changing the rules of the game, and this, I think, is not only bad for Adivasis, but for the health of the criminal justice system, because with such kind of changes, I think no one is going to say that we have a civilized, progressive, modern, liberal criminal justice system. Thank you very much.
Thank you very much for that, Professor Mustafa. Professor Mustafa might need to leave earlier. So for those who have questions or comments on his presentation, please use the Q&A function below. While waiting for others, I hope you don't mind if I have a question for you, Professor. Sorry.
All right, okay.
Yeah. Maybe just your thoughts. This is also from the author's a discussion with them. From what, how is the evolution of the Adivasi jurisprudence from the Patalgari movement? Like where is it? Where do you think it's headed from here?
No, ideally it should have become hugely popular, and because it was an assertion of autonomy, an assertion of right of self-determination, and people telling us that these are our constitutional rights. But people who are involved, intellectuals, etc., the way they have been, hauled up by our criminal justice system, the message was that don't do it. So there is a great promise in such kind of a movement, but the state has responded with a very, very heavy hand against people who are involved in it. And therefore, the benefits which would have accrued to us from such a popular movement, and a movement where there was such a self-assertion of one's right, have not really benefited. It could not become a widespread movement because of the response from the state.
Thank you very much for that, Professor. Anyone else using our Q&A? Not, you can just raise them later. Hopefully, Professor Mustafa is still can still a little bit longer with us. Thank you again for reiterating how the whole system, like the laws are criminalizing indigenous peoples merely for existence, really, and of course their way of life. Now we move to our next speaker, Justice Anjana Prakash of the High Court of Patna and Senior Advocate at the Supreme Court of India. So Justice Prakash was designated as a senior advocate and elevated as the first woman judge of the High Court of Judicature at Patna in 2009. On the bench, she adjudicated on a wide variety of constitutional, criminal, and ordinary civil matters until her retirement in 2016. She has practiced at the Supreme Court on issues of constitutional law and criminal law in particular, and has appeared in numerous cases to protect ordinary citizens against state arbitrariness. She is an accomplished writer, having revised and edited leading legal texts on criminal law, and also writes regularly on legal issues for popular news portals. A staunch believer in human rights and the rule of law, she is committed to the cause of social justice. Justice Prakash, please, you have the floor. Kindly unmute yourself, please. You're still muted, Justice. Yeah, voila.
Done?
Yes.
Good evening, everyone. And first of all, I must congratulate Shomona and the team for bringing out this book. I must say that I'm completely overawed and humbled by what they have done. The kind of research that has gone into it is simply mind-boggling. I must say this, even though I must say, also confess that I was so depressed looking, reading the contents of it. But I'm also, conscious of the fact that uncomfortable facts must be told. And unless we are confronted with these facts, I'm sure, we will not be able to, find a new solution to it. We generally know, that these kind of things are happening. But when there is a research done of the kind that Shomona and the team have done, I think, there'll be a lot of rights activists who will benefit from the basic structure of the book. They can build up, lawyers can also build up from this book, taking the cue from the book. And therefore, I'm sure, in days to come, it's going to be a very helpful research paper. But, as a criminal lawyer, I must say, I read the parts, where the book has sort of, looked a little, what would you say, disapprovingly of the colonial regime and the way they treated the Adivasis. I am from Jharkhand, and I found somewhere in the book, that the first revolt of, the Santhalis happened in Jharkhand. So I think somewhere along the line, maybe the genes have passed on to me, and I feel, that is still alive in me, maybe. That's what's keeping me going. So where, Jharkhand is concerned, let me tell you, that when we were practicing, I was not conscious, that there was anything like Santhal Pargana Tenancy Act and the Chota Nagpur Tenancy Act. But when I had a chance to go through them, I really wondered at the kind of groundwork that the executive, the people, the government had done at that point in time. The kind of groundwork. They thought of the trees, they thought of the produce of the trees, they thought of the ponds, who is to use them, why the land should not go to somebody else who's not an Adivasi, etc., So mainly, the way they looked at the Adivasis was not that they were a problematic, tribe. They didn't look at him like that. They looked at them that they had a difference, they were indigenous, and they needed to be treated differently. I'll just read out, some portions. I have, the first few editions of the Santhal Pargana Tenancy Act, and it might just, help us to get things in the context of how we were before our independence and how we have shaped, after the independence, even though the concerns have remained the same, how we've looked at these concerns. That's the major point. It is about a note of Deputy Commissioner of Santhal Parganas. It says the special administrative system, which in essential features is intrinsically sound, was designed to protect the interests of the Aboriginal, to enable him to grow and develop in a natural way. So a natural way which is peculiar to himself, not, assimilation as we know it. It is of a different kind that they were thinking of. Then again, the committee met for the first time in Patna on 18 December 1937 and submitted its final report to the government on 10 September 1938, embodying its recommendations. Now, what were the concerns? The concerns were that since the Special Tenancy Act of the district is closely bound up with the question of the protection of the Aboriginal cultivator and the special system of administration, the committee also made a general examination of the state of the tenancy law, which was very, very important. Protection of the cultivator. Now look at this, the person today, all left parties, they say, the person who owns the land will till the land. So the protection of the cultivator, the village community system and the Pradhan system. The committee also examined the question of local self-government, meaning that there was to be a self-appointed government local self-government, and possibility of economic development. So keeping everything balanced, they thought, of a very well-calibrated tenancy laws, which was to protect as well as to help them develop to the best of their ability and in their own way. The other thing, I must, about criminal justice, it says, the special criminal jurisdiction mentioned above was established for various reasons. It's about, sessions cases, etc., etc. Investigation of crime over a large area was performed by an untrained indigenous police agency. Please take note of this, untrained indigenous police agency. It was necessary to safeguard the integrity of the special laws of the district and to prevent differences of interpretation between the Santhal Pargana civil and revenue courts on the one hand and the High Court on the other. In those early days of administration, it was necessary to simplify the Court of Justice and to make it easily and promptly available to the people and to introduce an element of coordination in all branches of administration to secure stability of the local laws forming the base of the administration and the continuity of its interpretation. Now further, as the people progressed, feeling that criminal justice may be colored by executive considerations became manifest, and the power of the district deputy commissioner to enhance sentence on appeal, a power which elsewhere is not vested in any authority lower than the High Court, attracted criticism. The committee therefore recommended, some change then. And then the Santhal Pargana Justice Amendment and miscellaneous provisions came into existence. Now this, we are talking about, 1938, etc. Now let's, turn the clock and come to 2015. What happened was that on 9/6/2015, in the district of Palamu, Jharkhand again, the district police, with the help of Cobra unit, they murdered 12 persons. 4 of them were children. One Jawahar Yadav, he was the informant, but he was not heard. So he filed a writ application in the court. And in this time, the CID was holding an inquiry. The reason was, of course, because the high police officials, they were involved. Then what happened was that when Jawahar Yadav filed a writ application in Jharkhand High Court, it ordered a CBI probe on 22/10/2018. Now there is, at that point in time, there was one political party, which was, the ruling party then. Okay. So when the CBI, when the court ordered a CBI probe, the state of Jharkhand, it came in appeal before the Supreme Court. The Supreme Court dismissed the appeal on 22/2/2019. That is about more than 3 years ago. Now the complaint was this, that the DGP, imagine a police official at the rank of the DGP, had actually scuttled the probe, and therefore a CBI inquiry was necessitated. Till date, the CBI inquiry is going on, and I am told that they are about to close the investigation. Now, what has happened is, that when the 4 children were killed, the Cobra unit and the Jharkhand police, they actually dressed, the crime scene, in the sense they put on clothes upon the deceased, showing that they were Maoists. But what happened was that, the holes where the bullets went, that did not match with the holes on the clothes. And therefore, the cat was out of the bag. This is just an indication. As a criminal lawyer, what I understand is that at the point the occurrence took place, that is on 9/6/2015, all the material had already been collected. The objective evidence has been taken, etc., all that had been taken. The statements also had been recorded. So when the CBI was told to investigate in 2018, what did it have to do? According to me as a criminal lawyer, both as a prosecutor and a defense, I will say that the only requirement was that you examine the witnesses once again, if at all that is required, and you collect, whatever that there is, the post-mortem report, etc., and you file a charge sheet. What is taking them so long? Then, the other thing that I read in your book was about the definition by the Gujarat government in 2017 about the Gond tribe was that they were black, alcoholic, and criminal. Now, so we, when you look at the way the government is, viewing a certain sect, a certain citizenry, what do you see? You see that, neither is there any concern for their development, nor is there any concern for their protection. But the concern is for the otherness. You create, an other sect, which is not allowed to assimilate, even though you keep propagating that you wish to amalgamate or assimilate the entire, the population into one. But this is not happening. And these are the things, when you look at it, then it's very offensive.
Justice Prakash.
Yes.
Just
I think I'm done. I'm done. Thank you.
Oh, all right. Thank you very much for that in trying to dig deeper into the book. And it is, thank you for pointing out that because it is one of the objectives, I think it was mentioned at the very end of the book, that hopefully this will be a beginning for further studies on criminalization of Adivasis and trying to, as Professor Mustafa had mentioned, trying to rewrite a criminal justice system that is more responsive to what is needed, that is what needed for Adivasis for this time. The link to download the book is shared in the chat box, so you can access that now and later look into it after our presentation. Thank you again, Justice Prakash. We'll just, because we still have a lot of speakers, the question and answer will be at the very end of after we finish all the speakers. So our next speaker is Professor Virginio Sasa, who is a current visiting professor at the Institute for Human Development in New Delhi. He has taught sociology at the Delhi School of Economics, Tata Institute of Social Sciences, Guwahati, Northeastern Hill University, Shillong, and Tezpur University. He is the author of several books, including State, Society, and Tribes, Issues in Post-Colonial India. He has been the chairman of the high-level committee constituted by the Prime Minister in 2013 to study the educational, health, and economic status of the tribal communities in India. Professor Sasa, please, you have the floor.
At the outset, I thank you. I thank the International People Rights International for giving me this platform to speak at a book launch. And I must congratulate our advocate Somona Khanna and her team for this excellent work on criminalizations of the Adivasis and the state legal system. Now, this is an issue which has brutalized the tribal communities historically and even in current times. And yet it was never given the kind of attention that it deserves. And I think this is a book which is going to open, and I hope that there will be new lens from which the Adivasis will be looked at after having read this book. Once again, congratulations. Now I'll just move away from the key ideas of the law and the criminalizations, and I would like to look at the Adivasis as a society or as a social category from the larger historical and the societal perspective. And I'm here talking about Adivasi here, both in terms of, let's say, a scheduled tribe, but also I know that not all scheduled tribes call themselves as an Adivasis, and therefore my primary focus is on Adivasis. It basically means that those who have been living in the peninsular India. I think much of the problems of the Adivasis is, to my mind, primarily rooted in the legal structure, legal and administrative structure. And, this legal and administrative structure is actually what has, in a way, turned them into being identified as a criminal, and also whole process of criminalization. Is to the law that we know, and the book rightly points out that Indian Forest Act, in fact, identified the very way of life and the social and the economic and cultural practices of the tribal communities as basically a crime, and therefore they have to be punished. And so has been the case with the, what is called the Criminal Tribes Act of 1871. And therefore you find series of laws which have came around during colonial period, has criminalized, and this has continued in post-independent India through introduction of legislation such as the Wildlife Protection Act, the Forest Conservation Act, and we all know as to what these acts have been doing it to the Adivasis living in, let's say, in the peninsular India today. Now, I think we have to look at this in a historical context. And as I said, much of the problem is rooted in legal and administrative structure. And precursor to this kind of act which criminalizes tribal communities was also in the context of land and revenue settlement, which just a little earlier Justice Anjana Prakash was referring to. I think it is the land and revenue settlement which the British introduced, which actually led to our various kinds of problems of the Adivasis in India. If you really look at the land revenue settlement of 1793, that is the permanent Zamindari settlement, but you really find that Adivasis, all the occupied land, they had no tradition of reading and writing and record keeping. And land and revenue settlement, you find that as British were moving into the tribal areas, you find they were opening it up, and a lot of people from the plains were moving into the tribal areas. And they used the administrative setup or legal and administrative structure which was there in order to see as to how they can fabricate, forge documents, and take the land from the tribals, non-tribals, and the whole process of alienation that really begins. So on the one hand, you find that there is alienation of land from tribals, non-tribals. On the other hand, you find that from the 1850s onward, you find that the forest on which they were largely dependent for their livelihood, that also being taken away by the colonial state under the state forest management. So both the land and the forest, which is the life support system of the tribals, started dwindling. It's going from the from their control to the control of the outsiders and to the control of the colonial state. And that's, we find, is the real problem of that. And it is in view of this that they raise Trojan revolt, rebellions, series of revolt and rebellions from the late 18th century to almost throughout the 19th century. And that is what really put them into criminalization, in the sense that because they protested, they were revolting, the rebellion against the kind of structure and the system that was emerged. They were being identified, they were put into they wrote under the what is called the criminal legal systems, the police, with the court, with the laws, with the judges. And that is where you find an exposure, and they were really put into jail for years, sentenced to death, and so on and so forth. At least we know about the leaders who have been there and who are today are considered as martyrs. Now, this was the process. So this process of twin process, what you find in case of tribal Adivasis is that there are two kinds of colonialism that at work. One was this legal and administrative structure, which gave control to the British over the tribal lands and tribal forest. On the other hand, there was a colonization of the people from outside moving into the tribal areas and taking away the land. And therefore, this simultaneously, there were two kinds of control that were taking place. One is of, let's say, the colonialism of the white. The other was a sort of colonizations of the people from the plains. These two processes had been going hand in hand, let's say, in the colonial India. And this continues in the post-independent India. That's the kind of structure. So the colonial structure in fact, is well entrenched even in the post-independent India. So in post-independent India, yes, we became freedom. We are treated as citizens. We have representation in the parliament and state legislature and state employment and higher education institutions. But in spite of all that, if you really look at the share of the representations and their, let's say, economic and social development, they really remain at the bottom of at the bottom. So that's the kind of a structure. They are disproportionately the people most largely in the people living below poverty line, illiteracy, poor health status, and so on and so forth. So that's the kind of conditions which have come, despite the fact that after independence, we had a constitutions and a constitutions on which we boast, on which India goes over the world and say these are the kinds of provisions we have for the indigenous people or for the tribal people. And yet, if one really looks at the constitutional provisions, you find that it hasn't really worked. It hasn't really worked in any way. There has been a sort of safety valve, that's all. It hasn't really worked, in my opinion, it doesn't really work. That's the kind of a problem we have. And despite therefore constitutional legal protective mechanism that we have in the constitutions and even law by different states in terms of restricting the alienation of land from tribals, it is going on. That's the picture. So in other words, you find that colonialism, which was so well entrenched during the British, in fact, is well entrenched even in the contemporary times. And so you find you can take away the land. You have State Acquisition Act of 1894, through which you find that hundreds of thousands of acres of land were taken for the development, for mineral exploitations, for industries, for hydraulic diamond projects. And you imagine as to how many people really were displaced from their land and resources without proper rehabilitations. In fact, of the people displaced, almost 75% of them were not rehabilitated at all. Of the people displaced, 40%, in fact, turned out to be the tribal communities, Adivasi communities. So that's the kind of situation. The forest, we all know that they were there. They are turned into illegal occupants, and you find that they have been constantly being thrown away, rather than being punished. They have been brutalized by the forest department, and also, as to how the Supreme Court has really treated them in terms of their evictions. So these are the kind of issues that we really find it. And therefore, what I find is that unless the Adivasis are given a kind of right to self-determination, or what we call the self-determined kind of development, I don't see that there is any hope as far as the Adivasis are concerned. Because Adivasis in the last 75 years in India have been dominated, have been taught, have been educated from a lens which is an alien. It is all of a colonizing process has been done. Colonizing over land, resources, colonizing over educations, the whole colonizing practice of the health and so on and so on. So you find that throughout the colonization process is there. And therefore, until the colonization process is addressed, or colonialism is addressed, I don't think there is any hope for the Adivasis. And therefore, in order to address that, I think what is most important is that we should see if the constitutional provision, the protective provision, is respected in letter and spirit. And if that is really done in letter and spirit, I'm sure that there will be considerable substantive transformation as far as the Adivasi issues are concerned. The law which is meant in order to protect the tribals, if they are respected, then I think there will be a great deal of transformations. If the law like PESA or even the Forest Rights Act is in a way synchronized, all acts are synchronized in terms of provisions of the PESA and the Forest Rights Act, I think there will be a great transformative process as far as the Adivasis is concerned. I think this is really is the problem. And therefore, only hope the tribals have in order to get out of this impasse, legal, administrative, and other ways, is actually to have a kind of self-determinations. And self-determinations, I'm not necessarily saying that in terms of secession. It is not really possible. It is in terms of the fact that tribals should be allowed to determine themselves in terms of the constitutional provision, in terms of legal entitlements. And the moment you find that they assert what is really happening of late is that you are criminalizing them by calling them Naxals, Maoists, anti-nationals, and so on and so forth. And therefore, you
Professor.
put them in language immediately. Thank you so much.
Sorry, I had to cut you. Thank you very much for that. And thank you also for trying to link what has been discussed earlier by Justice Prakash regarding alienation and otherness and how this is linked to colonization, and for reiterating the importance of making the spirit and letter of the law work for Adivasis, and providing a picture that is, although sad, is a reality that without self-determination, really, for Adivasis, there will be no hope for the struggles that they're currently going through. And also, sorry for mispronouncing your name, Professor Kaka. I'm so sorry. I'm so sorry for that. Again, thank you very much. We have a question for you, but we'll take that at the very end. Our next speaker is Miss Ann. Dilip Chakma, sorry. He's the Executive Director of Indigenous Rights Advocacy Center, who is IPRI's national partner in India. He's a member of the Chakma peoples from India. He's an experienced lawyer who has worked with several human rights organizations and networks, including the Asian Center for Human Rights. Dilip was also the founding president of the Indigenous Lawyers Association of India. Dilip, please, you have the floor. Thank you.
Joyce, am I audible?
Yes, very much.
Yes,
You're good.
yes, thank you, Joyce. Again, like this book has actually discussed in length many of the constitutional provisions that is supposed to protect tribal communities in India. In fact, Professor Kaka just mentioned some of these specific legislations, FRA, PESA. In fact, there are specific piece of legislations for certain states in the Northeast India and even in central in mainland India in the form of 5 and 6 schedules. In fact, there are also provisions specific to states like Nagaland, Mizoram, Manipur, and a few states in the Northeast. Despite all of these, the question remains why tribals continue to face criminalization, violence, and impunity at the hands of both the state and non-state actors. So what I'll try to do in the next 5 minutes will be try to put some country context and deal with some of the current cases of criminalization that we have been dealing with. In fact, in the last 9 months, we have intervened in 121 cases of criminalization against indigenous communities in India. These are not the only cases we have documented. The documented cases are more, it's like it goes into a few hundreds. So out of these 121 cases of interventions we have made, in fact, 50% of these cases, which are like 60 cases, involve criminalization of some kind against tribals by the police, forest officials, and in many cases by public officials. And some of the other cases also deals with atrocities by non-state actors, including armed opposition groups, including by non-tribal communities or those from other higher castes, and also cases that deal with, denial of basic government welfare schemes by government. And in fact, a major chunk of these cases also deal with custodial deaths. I remember, I think we have intervened in 7-8 cases of custodial death cases in the last 9 months, and 9 cases of this intervention made in the last 9 months also includes forced eviction, affecting more than 300 tribal families. Of course, evictions that we have recorded in the last 9 months have cases come from different parts of the country. Assam in the northeast, Gujarat, Maharashtra in the west, Jammu and Kashmir in the north, and Tamil Nadu. Most of these cases have, the pan-India kind of character in the way we can understand the trend of eviction that communities have faced. In fact, these have increased in the last 2 years. I think our documentation shows, there's a marked increase. More so during the COVID lockdown, I think, the cases of eviction seems to have increased manifold. Another issue that I see, as someone who is engaged with the indigenous rights movement is, repression against human rights defenders indigenous human rights defenders or human rights defenders in general. Of course, we have heard a lot about the UAPA, how it is misused, to target specific human rights defenders. Of course, they do also target indigenous human rights defenders. When we talk about misuse of these draconian laws, the first names that comes to me in recent case will be Father Stan Swami, of course, who died in judicial custody last year. Of course, Hime Markham, who has been in jail, since 9 March last year, framed in 4 or 5 cases. She, as of latest updates, she had obtained bail in 2 cases. She remains in jail because there are 2 or 3 more cases where she is still, fighting for bail. Of course, the list also includes many others. If I remember correctly, some of the documented cases against indigenous rights defenders. One being Balsing Sastre from Madhya Pradesh, who was actually threatened with expulsion from his district under some specific Madhya Pradesh State Security Act, last year. And another being Baldev Murmu, very recently, I think, as recent as last January, I think, where he was illegally detained and kept in custody for more than 48 hours in Jharkhand. Of course, we go to the north side, we have Pranav Dole, actually, who is an indigenous activist from the missing community, who was declared to be a doubtful national, last December, and his passport, had been, renewal had been denied by the authorities because of what he does for the communities he's fighting for. Again, of course, the data maintained by the government of India, by the Minister of Home Affairs, we don't know how much to trust them. Of course, Paijan Sir has doubted some of the data. We don't know because there are no desegregated data on certain things. We don't know how many torture cases are there in India. We don't know how many have been killed in judicial custody. We don't know how many indigenous members, in the country have faced displacement, or how many have been evicted. All the records we have is through documentation done by certain organization activists, because the government doesn't maintain specific data. This one main concern again, which the government should be doing, so that we get a trend of how the real situation on the ground is with respect to indigenous communities. So if we go back to the data, of course, crimes against scheduled tribes seems to have been increasing the last 3-4 years, because the record shows in 2018 it was like 6,000 some cases. In 2019 it increased to 7,000 to something, and in 2020 we have over 8,300 some cases of atrocities against as part of the National Crime Records Bureau. Again, of course, if we look into the data again, the same database between 2017 and 18, we have seen a record increase of 15% of 50% increase in crimes against women and children who belong to the scheduled tribe community. Of course, there are many recent cases of innocent tribals being, criminalized, framed in false charges. Very recent cases of Sanjay Mazi and Birsa Mazi of Jharkhand, and poor, laborers who don't even have the money to pay, fees to the lawyers, who have been subsequently found to be innocent. Of course, I want to bring this case of Swati Kali. I think Professor Kaka had mentioned about the Criminal Tribes Act. Swati Kali is a member of the Padi community in Maharashtra. She have been, and the Padi community is one of the denotified tribes. They have been considered to be one of the 191 tribal communities in British India who have been declared to be criminal. So these Padi communities and communities like the Padi, similar situation, continue to face, the historical legacy of being branded as a criminal. So Swati Kali, whose husband has passed away in police custody last year, she continues to fight for justice. So this is an example of how these vulnerable communities like the Padis continue to face criminalization long after this act has been repealed. Of course, when we talk about tribal rights in India, we also have to be mindful about the militarization aspect of regions inhabited by tribal communities, which is mostly true for the northeastern part of the country, and also states affected by the left-wing extremism. because if we look into the cases of rights violations coming from, because militarism, this has also led to many cases of rights violation. If we look into the last couple of months, we know what happened in Nagaland, December. 13 innocent Nagas have been killed in extrajudicial killing by the military. Of course, if we look into Chhattisgarh again, we have these cases of 2 women having been detained and who subsequently were found to have been dead in police custody last year. Of course, on the other hand, in areas where we have seen militarization, like the Northeast or in the Naxalite belt, we also see innocent tribal villagers being subjected to extrajudicial killings, kidnapping, and torture by the Maoists itself on charges of being, police informers. And in fact, if we look into the last couple of months, also we have recorded 4 or 5 cases where, there have been killings by the Maoists on the suspicion of this particular victim doing police informers.
Yeah, just if you could kind of
okay, just concluding. So yeah, in light of the situation in India, of tribals in India, I think it's very important. This book has come, the way it has come, the time. It's very important. Like Anjana Ma'am has said, rights activists will benefit from this book, and I have no doubt. And I'm really hopeful that this book will generate the awareness, the attention and action that it really deserves on tribal issues in India at this moment of time. And I'm hopeful, like Ma'am said, tribal rights organization activists will really, really use this book as a very strong tool, to advocate, to push for policy legislative changes in the legal framework in India, and also advocate for effective implementation of whatever laws we have in the country. Thank you very much.
Thank you very much for that, Dilip. And thank you also for reiterating one of the points that's been highlighted in the book regarding the historical legacy of being branded as criminal crimes and how they're put in that cycle of criminalization that also affects their development in general. Thanks again for that. So our next speaker is Ms. Anne Nurgam, but I don't see her with us unless I'm just missing it. Yeah, so while waiting for Anne, hopefully she can join us. Let me call on this Special Rapporteur on the Rights of Indigenous Peoples, Jose Francisco Calichay. He was a founder of different indigenous organizations in Guatemala, ambassador of the Federal Republic of Germany, president of the Committee for the Elimination of All Forms of Racial Discrimination, director of Human Rights at the Ministry of Foreign Affairs, member of the Presidential Commission Against Discrimination and Racism Against Indigenous Peoples, and president of the National Reparation Program for Victims of Internal Armed Conflict. Special Rapporteur Calichay, please, you have the floor.
So good evening, good afternoon, good morning to all of you. Thank you very much for the invitation. It is a great honor and privilege to join you today and share remarks for today's launch of the book, Criminalization of Adivasis and the Indian Legal System. I would like to congratulate Indigenous Peoples' Rights International for commissioning and publishing this important work, examining the dimension of criminalization of Adivasis people in India. I would also like to congratulate Ms. Shamona Khanna, Asha Sahena Puja, and Khushbu Parekh for undertaking the significant task of writing this book. Your work in carrying out this study has led to foundational document on this critical issue. I want, of course, thank the organizers for the opportunity to understand a little about the Indian legal system and the situation of the Adivasi people. After listening carefully to the experts, I can only say thank you very much for that opportunity. Of course, the organizer asked me to make some comments on what I hear and on the situation of the Adivasi people. Raising the book, as we have here, the legal system in India is unfair, when it's applied to the Adivasi people, especially to human rights defenders of the indigenous peoples right in India. Specifically, the Adivasi people, which has essentially shown the execution of inadequate form of the Citizens' Rights Act. The book and the analysis that we have here today give us a panorama to understand the situation of the Adivasi people. And I will not stop on the analysis of the book. I will reiterate what has been said previously since the mandate of the reportership. As you know, the United Nations Special Rapporteur on the Rights of Indigenous People has on many occasions expressed grave concern in the drastic increase in attacks and acts of violence against criminalization of the threats aimed of indigenous people, particularly those arising in the context of large-scale projects involving extractive industries, agribusiness, infrastructure, hydroelectric dams, and logging, while the vulnerability of indigenous people to attack, notably will seeking to defend their lands, has been a long-standing concern of the mandate. The drastic escalation of such act in recent years continue to bring this issue at the forefront of my work. Particularly concern has been expressed for the Adivasis human rights and environmental defenders who notably oppose the expansion of private land ownership in India. In some of the reports on the rights of indigenous people in Asia presented to the Human Rights Council in 2020 by my predecessor, it was noted that these defenders were being increasingly threatened, criminalized, and accused of belonging to the left-wing guerrilla groups. This has resulted in an increase in extrajudicial execution and in the use of security legislation to prosecute indigenous leaders and community members who seek to claim their rights. In 2018, my predecessor also dedicated her thematic report on the Human Rights Council to a global analysis of attacks against and decriminalization of indigenous human rights defenders, and notably identify India as one of the countries among those with the highest incidence worldwide. Overall, the high rates of attacks against and criminalization of Adivasis human rights defenders in the region and often unreported and do not reach the international community. In my own report, I have also addressed these serious issues and the significant impact that criminalization has for indigenous people enjoyment of their rights. My recent report on COVID-19 presented showed the information from Asia has highlighted the legislative proposal and state sanctions laws that reduce penalties for environmental violation, criminalize indigenous human rights defenders, and weaken or remove environmental impact assessment and public participation requirement. Additionally, the enforcement of COVID-19 measure is being used to strengthen authoritarian and militarized response and a crackdown on civic space as laws are enacted that restrict freedom of expression and target human rights defenders. Furthermore, in my report on the rights of indigenous people in urban areas, I underline that the decriminalization of indigenous people engaged in peaceful protest to protect their lands have exacerbated the encroachment on indigenous traditional land and territories. Beyond thematic report, I would also like to make note of several communications submitted by this mandate to the government of India, highlighting the human rights challenges for Adivasis, including the criminalization and violence committed against Adivasi human rights defenders. Most recently, in August 2021, I submitted a letter requesting further details from the state on information received concerning abduction, police violence, and arbitrary detention, and the process against several human rights defenders working to protect the rights of Adivasi people. Previously, in January 2019, a letter was also submitted regarding information received concerning attacks carried out against Adivasi human rights defenders on 8th of November 2018 in East Jaintia Hills. Through this communication, authorities have repeatedly been urged to take action to improve the protection of Adivasis, but have failed to do so. I will not say anything more. Just to conclude, I would like to reiterate my gratitude, my recognition, my congratulations to those who directed this important study, which give us the opportunity to publicize the serious situation in which the Adivasi people live. That this study may be the first of many others in this subject of criminalization of the activities of defenders of the right of the Adivasi people. This book also invites scholars, legal professionals to deepen the study of the legal system in India and to propose change in the legal system to achieve equity for the Adivasi people. Congratulations again. Thank you very much.
Thank you very much, Special Rapporteur Kalichai, on that, and reiterating the work that your office has done and continue to do for the Adivasis in India. Thank you so much. I think we still don't have Ms. Anne Nargam, so we can just move to our last, or unless Anne comes in, who joined us in real time, Ms. Ida Martirius Nehad from the Office of the High Commissioner for Human Rights in Geneva. Ms. Ida, please.
Yes, thank you very much, Joyce, and thank you very much to the organizers for inviting me to this really interesting event. And I want to add also my congratulations to the drafters of this really comprehensive study on Indigenous rights in India, which is often missed or not very well understood by us here in Geneva. So it's a really useful tool for us working in the human rights system here. So I'm going to be very brief. I just wanted to sort of highlight a little bit some of the work of the UN human rights mechanisms on Indigenous people's rights in India. And firstly, why is it important to highlight? Well, India is party to all of the core human rights treaties, as you know, including the Convention on the Elimination of Racial Discrimination, as well as the two covenants. And with these commitments, India undertakes to ensure its laws and policies are in line with the obligations it signed up to. So with that, let me start with some of the highlights from the treaty bodies that I thought might be worth flagging in this forum. So the last review by the Committee on the Elimination of Racial Discrimination was in 2007. And already then there were quite a few concluding observations that made reference to protection or lack of protection of Indigenous people's rights. Firstly, for example, the review noted that India does not recognize tribal peoples as distinct groups entitled to special protection, and that it does not fully implement the rights of ownership, collective or individual, of lands of tribal peoples. With regard to discrimination, they raised the concerns over the loss of affirmative action rights if Indigenous peoples, if tribal peoples convert to Christianity and Islam. So of course, a very topical area at the moment. At the moment, India is due to report again to the third. There was a list of issues that were issued in August last year, and reading through the list of issues, I mean, many of the issues of concern that were raised in 2007 remain, including land ownership in the context of the National Forest Policy, safeguards against acquisition of land, etc. So while the third review has not yet been scheduled, the office always encourages civil society submissions, and I think the the material from this study is exceptionally relevant in this context, and could be used for that. And finally, I wanted to also, again, under the third mechanism, maybe just raise one particular case that came up, in fact, last year, and it was under the early warning procedure. Under this procedure, the third committee can receive information and take urgent action when it finds that there's a sort of an early warning element. And this came up on the Lakshadweep development regulation, which, as you know, is a small island in the Andaman Sea, primarily inhabited by tribal people. And there was a draft development regulation that essentially removed very important safeguards for indigenous peoples there. Regarding land ownership, and that removed the sort of thresholds of free, prior, and informed consent. So the third committee took up that case and sent an urgent letter to the government on this, and that's of course public information and publicly available. But an interesting initiative. With regard to the international human rights mechanisms, trying to sort of point out the sort of lack of protection for indigenous peoples in India. Secondly, as you know, India is coming up for the Universal Periodic Review in November. This will be the fourth cycle. And when we go back to the recommendations that had been accepted by India over the last three cycles, many, of course, pertain to protection of indigenous peoples and tribals. And for example, in the last cycle, in the third cycle, which took place 4 years ago, there were a number of recommendations that had actually been accepted by the government, including a commitment to increase protection for tribal people, and a commitment to increase access to housing for tribal people, a commitment to increase access to education for tribal peoples, and a commitment to remove barriers to birth registration for tribal people. So a number of commitments have been made by India in the last cycle, and as you know, as many of you know, the submission deadline for civil society for the next cycle that's happening in November has just closed at the end of March. So I do hope that organizations participating today have been able to submit information for that. And then lastly, the special procedures. I'm not going to say much more, as the special rapporteur has given a very comprehensive overview. But I just wanted to maybe make mention of one particular other letter that was sent in 2020 by a number of special rapporteurs, not just special rapporteur on indigenous peoples, but also the one on environmental protection as well. And it was in relation to the draft environmental impact assessment notification that had been put forward that year. And that OL was sort of set out the various human rights concerns that the special procedures had with respect to that, including what it meant, what it would mean for the rights of indigenous peoples and their rights to land. A lot of the provisions in that notification were very, very concerning, including a sort of post facto element of impact assessment. So having an impact assessment being done after lands had already been developed, etc. So I think it was, I mean, both this example and the one on the third regarding the Lakshadweep regulation, I think were very interesting because both of them have not yet passed. And I think it was timely for the UN human rights mechanisms to put forward their interpretation or their assessment of these different pieces of policies, I guess, impacting Indigenous people's rights. So just to conclude, I think the importance of your work is especially so because of the basis that it represents for the UN human rights mechanisms to take action. So like I said at the beginning, I think the study is very, very helpful in that respect, and can feed into various different processes. As we know, the Indian judiciary does pay attention to international human rights obligations, does cite them, and authoritative assessments from the UN human rights mechanisms can help in that way. And then maybe just very lastly, just to respond to some of the issues, some of the panelists have raised issues related to the protection of human rights defenders, including Indigenous human rights defenders. This is an issue that the office follows very, very closely. And the High Commissioner herself has spoken out on various occasions, including especially on the Unlawful Activities Prevention Act, and how that has been misused in many respects to criminalize legitimate expression and activities by human rights defenders. So this is something that we do very much watch carefully and raise publicly, but also privately, not only through the mechanisms, but also through the High Commissioner's voice. So I'll leave it at that. And thank you very much again for the opportunity to be with you today. And it's been really very, very interesting. Thank you.
Thank you so much for that, Ida. Thank you for providing and reminding us about the work that needs to be done with the mechanisms, along, of course, with the special procedures, with the special rapporteur here now, to provide our communications and submissions. I still don't see Ms. Anargam, so I think we can now play the video from Ms. Alvina Alameta of the European Parliament, because he's unable to join us in real time before we move on to our question and answer. Ivan. Thank you.
Honorable speakers, participants, organizers, I would like to thank so much the Indigenous Peoples' Right International for inviting me to this event. Unfortunately, I cannot be there today in person, but I promised to say a few words via video today. We know well the challenges the Adivasis face today in Indian society. They continue to face prejudice in the mainstream society and are the poorest section of the society. The exclusion relates to many issues, for example, land and forest resources to livelihoods, health, gender equality, schooling, water resources, governance and poverty. And the threats to lands, territories and resources of Adivasi and their rights to these constitute an existential threat to their distinctive way of life. The Adivasi communities have been bystanders to the Indian modernization that has had adverse effects on them. Millions have been displaced from their forests and other traditional lands by development projects such as dams, mines, industrial agriculture schemes and conservation areas. And the strive for development, nature conservation and climate change adaptation, all very important, have also been used to undermine the Adivasi communities and their rights and interests to land and territories. The new book on Indian legal system and criminalization of the Adivasis tells us a history of yet again another level of exclusion of Adivasis that they have faced over the decades. how the legal framework, together with the deep-seated attitudes and prejudice of authorities and the implementation of various laws, have created a web of legal and institutional systems that keep the Adivasi communities in a precarious position, denying them rights, justice and equality. As I was reading this publication, one thought kept coming back to me. How, as a member of vulnerable community whose very existence, culture and survival are so integrated to a legal system which undermines all that, do you look at the surrounding society? How do you make sense of the laws, restrict your reality and way of living? And how do you feel when the system that is supposed to protect you actually does the opposite? As a member of European Parliament and a standing rapporteur on India in the Committee of Foreign Affairs, I want to learn more all the time about the Indian society and how human rights, including indigenous rights, are realized in India. And while mine is not the parliament that changes the Indian legal system, it is nevertheless a responsibility of ours to reflect of these lessons learned with our Indian counterparts. The international commitments the Indian government has made to protect civil, political and human rights opens up a channel for us to discuss possible failures in doing so, also in the EU, not only in India. One of the possibilities for the EU representatives to address those failings with the Indian counterparts is the human rights dialogue that took place first time last year, after a long break. I call on this dialogue to be extended into a meaningful discussion with more transparency of issues discussed and decisions taken on next steps, also for democratic control and the civil society. And I do expect the rights of indigenous people to be included in the dialogue next time. Last year, the European Parliament also took a position of human rights issues in its report, of which I was the rapporteur. And in the report we called the Indian government to grant rights under the Forest Rights Act to Adivasi community. With steps like this, I hope that European parliamentarians can provide support to indigenous people in India and elsewhere for the struggle to realize their rights. I would like to thank again the Indigenous Peoples' Rights International for providing us in-depth and eye-opening book of this situation of Adivasi communities. I wish you will all have very interesting discussions today and trust that I will get to hear some of the conclusions and recommendations that are made by you today. Thank you so much, and I'm wishing you a very pleasant event and all the best for your struggle for human rights.
I believe that ends all the list of our speakers. Unfortunately, maybe Ms. got caught up with another meeting. So just for the question and answer that was raised, particularly for Professor Kaka from Santosh Gadam, what makes you argue that the problems of Adivasis are rooted in legal and administrative structures? As we have extended way our time, like maybe I'll give you 2-3 minutes to respond to this, Professor, please.
Yeah, see, the problem is that there are layers and layers of laws, as per my understanding goes. Now, what are the laws that work and what are the laws that don't work? Now, laws that are protective, that are aimed at securing and promoting the interest of the indigenous people or Adivasis is always compromise. Let's say, in order to ensure the kind of laws or other laws or policies that is there in order to have, let's say, a development. For example, you need mineral exploitation. Mineral exploitation is much more important than the fact that the tribal land has to be protected. So that's the, I'm not saying therefore, basically saying that among the laws, in my opinion, there is a privileging of law and there are others which are disprivileged. And invariably, I find that the Adivasi laws which are aimed at protecting are really subordinated, and therefore the larger laws, public laws, generalized laws seems to be more important. And thereby you constantly perpetuating the unequal structure or exclusion of the tribal communities. That's what I was saying. Even administratively, you find that unlike in the Northeast, where tribals are able to manage themselves, either through the through the autonomous district councils or through the state. Adivasis in Peninsula don't have, except for the village, they don't have any structure whereby they are really able to manage their affairs. So the whole administrative structure is top down. It's others who actually administer, others who actually bring about development of the Adivasis. And that precisely is what really the problem is. And therefore, order of educations, health, etc., is not really getting improved precisely because it's a top down and do not understand the kind of perspectives from which the Adivasis really look at the issues.
Thank you very much for that, Professor Kaka. I hope that responded to your question, Santosh. Any other questions? You can just place them at the Q&A, but maybe just to provide a round of like last thoughts from all our speakers who are still with us. Just regarding on what are the key, how do we move forward from here, knowing what we know now? Like, what are from your experience, Justice Prakash, Professor Kaka, and of course, Special Rapporteur Kali Chai is still here with us. Like, what are the most effective, like how do we move forward from here within the context, of course, of India? As an advice to indigenous peoples and that are working in defending their rights. Just a few thoughts on that. Justice Prakash, you want to go ahead? Yeah.
The only thing that I can say is, that first of all, the government will have to be conscious, that it has to enact laws, which is for the protection. It is not for criminalizing them. That is, the understanding of the book is also that, if they just read through the book, if the government reads through the book, they'll be able to understand where the priority should lie. It's how you look at it, that's the difference. And this is what I wanted to point out, from the pre-independence days to the post-independence days, look at the way the perspective has changed. Look at the way we are looking at the same thing. Is this development or is it going back? What are we doing? So the government, first of all, has to be sensitized, sensitized as to how to deal with it. It's not a problem that they're talking about. They treat it like a problem. It's not, Adivasis are not problems.
For sure, Justice. And thank you very much. Hopefully they do download our book, even the summary of the book. It's a 200-page book, and I'm sure government representatives will find it hard to actually go through, like most government representatives, I guess. Professor Kaka, any thoughts?
I have already said this earlier in presentation. Basically, to my mind, it appears, or rather, I am convinced of the fact that until tribals are given a kind of self-governance and therefore right of self-determinations with respect to the land, the forest and other resources, even education and language, I don't think there is a possibility of their development. I think so far what we have seen all through this 75 years of India's independence is that everything is being imposed and tribals have no say in the manner in which they can really develop. And therefore, if at all we think, then the well-meaning laws or constitutional provisions which is protected must be implemented, must be ensured. And people who do not really implement it, and particularly in the 5th schedule area, you find governors have power to say that any law passed by the parliament or state legislature may not be applied to tribal areas, schedule 5 areas, or applied with modifications, keeping the tribal interest in mind. But they have continued to extend all these kind of laws for the last 70 years. As a result of all these laws have very adversely impacted the Adivasis. So basically, point that I'm making, that let India respect its constitutions in letter and in spirit, and all the laws which it has enacted in favor or what protects us be implemented, and therefore the kind of space that is being given, it should really respect that. That's what my perspective is.
Thank you. Thank you very much for that perspective, Professor Kaka. I definitely agree. Dilip, do you have last thoughts before I pass it on to the Special Rapporteur?
Yeah, thank you, John. Joyce, I think one of the point I would like to raise would be, the urgent need to make access to the legal system more accessible for tribal communities in India, because the very fact that navigating the legal system is such a big challenge for communities like the tribals, the vulnerable communities. It itself one of the stumbling block, I think. In fact, some of the victims that I've come across, this seems to be the main, concern. In fact, many of them in India up to date are in jail either because they don't have the financial support to access justice, or they don't know the law or about the rights, or basically general lack of support. So I think there's an urgent need to, make access to the legal system more accessible. Yeah, thank you very much.
Thank you so much for that, Dilip. Special Rapporteur Kalichai, any final thoughts?
Yeah, thank you very much, Joyce. I think that I will use something that a constitutionalist from my country said in 1985 when we came back from the military dictatorship, and they were just making, or they were writing the new constitution of Guatemala. And he was using a medical terminology. And he said in those days, if an organ is not used, it atrophies. So I think that the legislation must be adapted to the reality and condition of all the inhabitants. But if they are not used, they will remain in disuse and will not and they are not going to work. The laws, if they are not discriminatory, it works only if we use the laws. This also conforms to international instrument and the special mechanism. So indigenous people has to use the special rapporteurship. And of course, we are here to hear and to work with you. So please use us. Thank you very much.
Thank you. Thank you so much for that, Special Rapporteur. Just before I leave it to Joanne to provide the whole general thought from their final thoughts, but just before I give it to our Executive Director, I'll just read the comments that were left in Q&A. From Dilip Kumar Das, so it's just agreeing that the victimization of tribals are done in many ways, and that the Forest Department, specifically in Odisha, in the name of Forest Conservation Act, evict, torture tribal, indigenous, and Adivasi peoples. And armed forces, which was mentioned earlier by Dilip regarding militarization, in the name of combing Operation Kill or injure the Adivasis by firing them. And he also mentioned the criminalizing laws that were also reiterated in the book, the Forest Rights Act. And the Forest Department never bothered to honor the provisions under the Scheduled Tribe and Scheduled Castes Act and the Forest Rights Act that are supposedly protecting the rights of indigenous peoples. And for Leticio Datuata from the Philippines, from Lambangian, from Barm region, a recent new region in the Philippines. My question is about the situation of Barm, as indigenous peoples are not recognized in their rights on ancestral domain, even though we have the IPRA and an explicit RA on the recognition of our rights, but instead approved the resolution number 38 to stop the process. So I think it's just a reiteration of how the parallelism of where the experience of indigenous peoples, regardless of having these protective laws in them. So that's what we have in the Q&A. Now I pass it on to John to officially conclude and provide us the closing remarks. John, please.
Yes, thanks, Joyce, and thanks to all the speakers for providing very substantive reflections, insights, and also some recommendations. I think the speakers were able to elaborate a bit more on the impacts of laws, both discriminatory laws and positive laws in which positive laws are not being implemented, and it's more the discriminatory laws that are being implemented. And also the issue of lack of access to justice, which is compounding this issue of criminalization and marginalization of the Adivasis. I think we cannot separate the issue of the marginalization and criminalization and the severe violations of the rights of indigenous peoples. It's also very insightful to hear from our international speakers, particularly from the Special Rapporteur, but also from the Office of the High Commissioner, on how the UN mechanisms are actually putting forward clear recommendations on how the government of India should uphold its human rights obligations also to the indigenous peoples, and highlighting the issues of addressing the criminalization, discrimination of indigenous peoples in India. And it's very useful to hear that there are very good recommendations from treaty bodies, and I hope that this will also be used within India to put pressure to the government to implement these recommendations. The other one is also hearing from the EU representative, the parliamentarian, where we can see the dynamics between the international relations among governments, which is another channel of raising raising attention to the human rights obligations of the government of India to indigenous peoples, and using international diplomatic channels to put pressure to the